Now on to some news regarding indefinite detention. This week, the California State Senate unanimously voted 37-0 to reject the federal government's indefinite detention powers as prescribed by the National Defense Authorization Act, the NDAA, nearly 2 years ago. The measure reads, quote, "It is the policy of this state to refuse to provide material support for or to participate in any way with the implementation within this state of any federal law that purports to authorize indefinite detention of a person within California." It was previously passed by the California State Assembly as well. Ultimately, if the measure is signed into law by California Governor Jerry Brown, it would make it very difficult for the federal government to use its indefinite detention powers, at least in the state of California. Elsewhere, the main plaintiffs in a long legal battle against the NDAA's indefinite detention provision are planning to file paperwork in the coming days to have their case heard before the United States Supreme Court. This would be the last remaining legal challenge available to critics of indefinite detention after a U.S. Court of Appeals ruled last year that plaintiffs lacked standing to challenge the law. Joining me now for the latest on this fight, Tangerine Bolen, founder of RevolutionTruth and a plaintiff in this NDAA case. Tangerine, welcome.
Thank you so much.
Let's start in California. Assuming Governor Brown signs this measure into law, how effective might it be in curtailing the government's indefinite detention powers, especially if other states pass similar legislation?
Well, it's a great question, and I have a two-part answer. The first is it's effective just in that all these groups have come together to fight this, and Congress is taking it seriously. So, I think that helps move us down to the end goal a little closer to really nullifying the NDAA. It's also, though, full of loopholes, and this most significant loophole that I saw was an over-reliance on habeas corpus. Habeas corpus is a measure of last resort. Someone can be indefinitely detained and held for a long time before the government actually honors habeas corpus. That could be 10, 15, 20 years. So it's kind of meaningless. And the issue with the NDAA is the suspension of due process, all of our rights, not just habeas corpus. So it's good and bad.
Well, let's move on to the other avenue that you guys are sort of working here, and that is asking the Supreme Court to hear your case. What are you hoping to hear from the High Court in response?
Well, first of all, that they take the case. They don't have to. It's a little bit worrisome because, as we've seen, the judiciary, even all the way up to the Supreme Court, has tended to defer to the executive while we're in this endless war on terror. So they don't have to take the case. They could say that this is all settled, this is the international laws of war, and this is what Congress decided, we're not touching it. We hope, obviously, they do take the case and that they take these constitutional issues seriously. There were two issues we brought forth, the First and Fifth Amendments, again, the free speech, freedom of association, and due process. We raised really significant, really pertinent questions all along the road. As you know, last year we won. And even the appeals court agreed that we raised very, very tricky questions. So the Supreme Court ought to take this case.
Many lawsuits against the government spying on Americans have been tossed out after courts ruled that they didn't have standing since they couldn't prove they were actually spied on. That's now changed in light of NSA revelations, and we'll probably see a lot more lawsuits come out. What new information may come to light? What sort of action might be taken by the government that could help your case and give plaintiffs against the NDAA standing that the appeals court said that they didn't have?
You know, that's such a great question, and I'm glad you asked it. As you know, Chris Hedges also was part of the Clapper case, one of the journalists that filed, and they lost on standing grounds precisely what you described. They couldn't prove that they were being spied on. Well, now we can. So, you know, it's a roundabout thing, but this can affect our case positively in that the government can't quite so easily squirm out of this and say, well, you can't prove anything, so you have no standing. In our case, it's really, really absurd. We were denied standing because you have to be indefinitely detained before we could have standing. Well, if someone's indefinitely detained, they're secretly, most often secretly arrested, they're held secretly somewhere, we don't know where. They're denied access to an attorney, no phone calls to family or friends, and it's legal now to hold them for as long as this government wishes. There's no way to even find those people. So, you know, absurdities abound, and hopefully we're going to continue to get judges like Judge Catherine Forrest, who really can see this all-out assault on the U.S. Constitution and start to roll it back.
Right. Moving on from state governments to the Supreme Court to now Congress, which is working on a new NDAA right now. Is there an opportunity during that process to rein in these powers? What should people know during this coming debate?
Well, there are several senators and congressmen and women who are really fighting to roll this back, but their efforts are being rejected at every turn. People in both the Democratic and Republican parties are halting them in their tracks and rejecting the amendment. So I totally applaud my friends and colleagues who are fighting this in Congress, just like I do those who are fighting in California and statewide nullification efforts. And I think what needs to happen, though, is every one of us sort of has this Achilles heel we need to deal with, and it's broken institutions, broken judiciary, whatnot, politics, whatnot. So we need to fight on every front, and the congressional fight matters, but right now is looking rather pessimistic.
Right. Well, it should be an interesting few months ahead. That was Tangerine Bolen, founder of RevolutionTruth and an NDAA plaintiff. Thank you.
Thank you.